Welcome, everyone. I'm Pat Palmiato, Director of the Olwyn Initiative for Corporate Citizenship at the Tuck School, and it is my great pleasure on behalf of the Dartmouth Centers Forum to welcome you today. The Dartmouth Centers Forum is a collection of centers at the college. We work together to respond to growing political, ideological, social, and intellectual dissonance that occurs both in society and in the academic institutions across the land. We hope to create a continuing dialogue about issues. We each year pick a theme, and this year's theme is conflict and reconciliation. We are pleased to present today's panel discussion, which focuses on labor issues in the digital age and looking at the products of labor and whether and how the effect of the digital world changes or has some kind of impact on the product of people's work and compensation as well as rights. We have an amazing panel, and it is my great pleasure to turn it over to our panel moderator, Professor Mark Dixon of the Sociology Department.
Thank you, Pat. Well, welcome. Thanks for coming out on a slushy Monday afternoon. Today's panel is about conflicts surrounding the world of work, how it's changed in recent decades, and the implications for various groups of workers, including intellectual and creative types, many of whom are well represented here in the Dartmouth community. Now, issues about work and who should get paid for what have been around forever. And they remain timely, obviously because of the current economic insecurities, but our panel is timely in another way too, in that it grapples with some of the changes in the world of work that are brought on by new technology. And so many social commentators over the years have talked about technological development and the expansion of our post-industrial workforce as making a kind of qualitative change away from the conflicts of old. And by old, we're talking about collective bargaining, labor unions, strikes over wages, things like this. Yet at the same time, even while unions have shrunk in comparison to just 3 decades ago, collective bargaining persists. And surprisingly enough, conflict over terms of employment has not gone away either, even if the terms of debate have changed markedly. So we've got 4 very interesting presenters today who are each going to talk about continuity and change in conflicts surrounding labor and the world of work, each from a distinct vantage point. We begin our discussion with some persistent themes and sticking points in labor relations, including processes of conflict resolution. And for this, we're fortunate to have Patty Anderson, labor economist, professor of economics at Dartmouth, and also Everett Marder, labor arbitrator and attorney who's been working on these issues throughout New England for a while. Given this starting point, we then turn to some of the new arenas of conflict brought on by changes in technology. And we have Bill Phillips, screenwriter, professor in film studies at Dartmouth, who has hands-on experience in where some of these issues came to a head as a participant in the recent writers' strike. And finally, we have David Seaman, an information specialist with Dartmouth Libraries, former director of the Digital Library Federation, who's going to bring us full circle to talk about intellectual labor and product in the digital age. Our goal is to foster a discussion with you all. So we're going to have pretty brief statements by presenters and then open it up immediately. So have your questions ready, and we're going to make sure that when you do have your questions, you speak on a microphone because this is getting recorded, and otherwise we will miss you. So it's my pleasure to turn it over to Professor Anderson.
Hope you got it already. Excellent. So as Mark indicated, my job today, sorry if I go to the microphone, my job today is to give you a little background on what's going on in labor relations throughout history and maybe where current events fit into that. Are new things really new, or is it the same old story? And so I'm starting with this supposed quote from Samuel Gompers, who was actually the founder of the American Federation of Labor. He was its president from 1886 to 1924. He supposedly was asked, "What do unions want?" And he said, "More." Now, the story is actually quite apocryphal, though he apparently had a much more nuanced and interesting answer, but this story lives on in labor lore, so I thought I'd pass it along. And this is really sort of the age-old story of labor relations, right? In that there's always going to be this conflict between labor and the firm, because what we're at core, we're thinking about dividing the rents, okay? Now, typically this is thought of as a fixed pie and sort of a zero-sum negotiating game. That's not always strictly true. There's possibilities that you can get increased productivity from higher wages, grow the pie that way, but at some point it is going to eventually come down to a point where more for the worker means less for the firm and vice versa. Now, as people, I think we're all people here, most of us who are workers, I think a lot of times we tend to think of the firm as some amorphous, faceless entity that's just trying to exploit the worker, but firms are people too. Firms are capital owners, okay? And so it's not unusual that we're going to get this conflict. Workers want a big return on the labor that they supply to the production process, and owners of capital want a big return on the capital that they supply to the production process. We get no output without putting them together. They both have this claim on the pie, and now they're going to fight over who gets what part of it. And as a result, we've got conflict, okay? Well, how are they going to work out this conflict? Well, they're going to try to bargain. How are they going to reach an agreement? Well, your first thought might be, well, firms have all the power. You know, they're the capitalist pigs or whatever, and so they're going to, rule the day. But there's power that comes from the threat of a strike, okay? Strikes are costly, and they're costly to both the firm and the workers. And the relative costs of this strike is what's going to determine who has more power, okay? Now, it's important to realize that this relative power that comes from the threat of a strike doesn't mean we're going to see a strike. This relative power is informing the negotiating process, okay? And so if it's going to be very, very costly for the firm to see their workers strike, we're likely to see a negotiated settlement that's somewhat more favorable to the workers. If, on the other hand, the strike is going to be much more costly to the workers, we may see a negotiated settlement without a strike that's more favorable to the firm. So we don't really know, we don't always have to see the cost of this strike. As long as both parties have an idea of what's going to happen if a strike occurs, we can come to a settlement and avoid the costly strikes. And in fact, strikes are pretty rare, and increasingly so. This is a graph of the number of work stoppages involving 1,000 or more workers. The Bureau of Labor Statistics has collected this data since just after World War II, and you can see there's a lot of fairly high years in the past, but in recent years there's just not a lot going on. Now, we do get some high-profile strikes, right? So in the 80s, we had the PATCO, the famous air traffic controller strike. Most people that are affected by strikes, it tends to be, baseball striking right before the postseason, hockey wiping out a season, and of course, God forbid, us missing our television programs because the writers go on strike. That said, there's, strikes do occur. The conflict is not always negotiated away. That said, this looks like it's more important than when you realize in recent times, this is the same basic story, but you've got some pretty severe strikes in the sort of immediate post-war period where you're losing a lot of time to strikes. I should back up 1 second, just a terminology thing. There's technically strikes and lockouts. Those are both work stoppages. There's sort of a technical difference between who initiates not working. I'm going to mostly use strike interchangeably, but it's not technically true. So, for example, the NHL was a work stoppage. The team owners locked out the players, so that was actually not a strike. It was a lockout. But for the consumers, it's all the same.
On this graph,
this is annual data, yes. So during that year, the percent of idleness is a percent of working time in that year. After about 1980, you can get all of these figures on a monthly basis, but in terms of, since we're just trying to look at the big picture, I went with the annual data. The Bureau of Labor Statistics has a great website where you can look up all these things and run a little interactive program where it lets you pull data that has all this stuff. Hours of fun for everyone. I recommend it. But upshot is strikes are rare, but they're still important because that strike threat is where we're getting the relative bargaining power of our two parties that are in conflict. Now, what are costs of strikes? So they're fairly obvious. I'm just putting the big ones here. Obviously, cost to the workers is they don't get paid if they're not working. Now, most unions have a strike fund. When you're paying your dues over time, part of that's getting put away so that you can get some payment while you're out on strike. The bigger your union strike fund, the better your workers can withstand being out on strike, the more power you're going to have as a worker. From the firm's point of view, again, lost output is really the problem, so the firm's losing revenue on the output that's not made. Now, interestingly, in the US, replacement workers are completely legal, not just temporarily during the strike. You can be permanently replaced. You can't be fired. It's this very tricky legal distinction where you can't be fired for going on strike. You can be replaced permanently, which means that as new jobs open up at the plant you were permanently replaced from, you're first in line for getting them. So the easier it is to replace the workers, the more bargaining power the firm's going to have. They're not going to lose as much output. The more the output is something that's perishable, the more costly a strike's going to be to the firm. All of these types of things are cost to the firms. Now, technically, there's cost to society as well. I know I suffered greatly for those 100 days that there was no new writing for television. But there can be, so there's the lost output is a cost. This is a loss to GNP as well. There's actually other costs. There's a classic article where it turns out, I don't know if everybody remembers a while back when it seemed like Ford Explorers were rolling over all the time when their tires blew. It turns out that almost all of these defective tires were made at one plant in Decatur, Illinois, that was having a horrible, horrible labor conflict. Basically, Bridgestone Firestone had imposed a new contract, so the contract ran out without a settlement. So the way the conflict, as I said, is usually resolved is you negotiate based on these strike threats and you come to an agreement and a new contract before the other one runs out, no strikes happen. The contract ran out. What basically the law lets you do at that point is the firm can pay whatever it wants, okay? If the workers want to keep working. They can work without a contract. Bridgestone Firestone imposed a new contract that was much worse than the one they'd been offering in the negotiations. They started hiring replacement workers. The strike lasted for a really long time. And it's actually during the period that you have striking workers back on the job under a bad, not new contract, temporary contract, working side by side with replacement workers, that you see huge spikes in defect rates that you don't see at Bridgestone Firestone plants in Canada that didn't have labor strife, and in Georgia, I think, some southern state that didn't have a union. So there can be real costs to these strikes beyond these simple sort of economic costs. Now, since we're going to be talking about the writer's strike, I thought I'd put this in sort of historical context a little. So mostly I think when we think about labor relations and unions in the US, we sort of have this, coal miner, auto workers, big industrial unions in mind. But the earliest American unions were in fact crafts unions based on occupation, which is what the Writers Guild really is. It's a craft union. And so most people point to the first sort of collective bargaining unit in the US as being shoemakers in Philadelphia in 1792, okay? In a sense, the Writers Guild and shoemakers in Philadelphia have a lot in common. They've banded together as an occupation to get paid more for the fruits of their creative labor. There is something unique about the Writers Guild in that what they're negotiating over is actually a minimum basic agreement. It's not your standard collective bargaining contract where it spells out exactly what everyone gets paid. It's actually a minimum, and individual members are allowed to negotiate beyond that on their own behalf. But really, ultimately, I think we're seeing that this strike, while thinking about digital rights issues, is really nothing new. It's really about how to share the rents that come from combining the productivity of labor and capital. And so, as I like to say, everything old is new again. Our panelist gave us this nice picture here of a Writers Guild demonstration last year. I think you recognize the forum. And then here on the left, we have our ladies tailors who are striking around the turn of the century, who want better piece rates for their work. Okay? Now, am I saying that there's no new changes with technology and labor relations? It's certainly true that most of labor law and regulation was really put in place in the 1930s. And so it clearly is not taking into account the digital revolution. But I think where we see this being an issue for labor relations and the conflict that we see is more in the case where the things that are mandatory to bargain over right now are mainly compensation, working conditions, etc. It's not required to bargain over these new issues that affect workers, like implementation of these new technologies that may, in fact, do your job for you and put you out of a job. So in terms of new digital media and the writer's strike, I don't think the conflict was really new. It was just, a conflict over compensation, no different than the Philadelphia shoemakers or the ladies' tailors might have worried about. So I think that sort of sets the stage. I'll quit that and let our next speaker take over.
Hello, thank you all for coming. I'm going to talk about the things that have been around for a long time. I think this was introduced in the sense that we're talking about things that have been around for a long time, and that's what I'm here to talk about. I'm a practitioner, I'm an arbitrator, I'm an attorney. I'm licensed in the 3 states of New Hampshire, Vermont, and Massachusetts, and I'm registered with 6 agencies that do arbitrations in labor disputes. So that just tells you that I'm not this is not theoretical. What I'm going to talk to you about is, in fact, how it works. That's the important thing. I think we all know that there are conflicts in labor issues. The question is, how do we resolve them? Is a strike the only answer? The question is, how do we get there? First of all, there are basically 3 different types of labor relations between employers and employees. One is referred to or called technically as at-will employment. At-will employment's easy because at-will employment means that the employer hires you with the understanding that he or she can fire you at any time for any reason or no reason, as long as it's not a bad reason. And what does that mean, bad reason? It means perhaps some violation of the law, perhaps some kind of prejudice or discrimination, and then it doesn't become a labor issue, it becomes a judicial issue. It goes to court because it's a violation of someone's human rights. That's one type of employment relationship. The second type of employment relationship is a government appointment, whether it be political or whether it be civil service. In any event, these are covered by the law. Generally speaking, civil service employees are not allowed to strike. They don't even get a chance to negotiate, although there always are associations that do make an effort at putting pressure on the government agency, whoever it might be, or whatever it might be. The third type is contract employment. whether this be a contract between an individual and an employer, and whether the individual and the employer work together, negotiate together, decide together, and agree together to sign an employment contract, and that employment contract provides all of the provisions within it, how the contract can be terminated, or if it is terminated, what the repercussions are. Generally speaking, one employee employed on a contract with one employer is not going to go on strike. There's no such animal. The third type, I think, is the type we're talking about here today, and what most of our panelists are most interested in, and that's the one involving labor unions. What is a labor union? A labor union is an organization of employees that agree to leave the negotiations for their contract up to the general will of the group. It's negotiated through the union representatives, and a contract of some kind is established. Normally, the contracts that's established between unions and employers are referred to as collective bargaining agreements. A collective bargaining agreement may be, it depends on the state that you're from. I know in Massachusetts, for example, collective bargaining agreements cannot exceed 3 years. So you negotiate, you form a collective bargaining agreement between the employee organization or union and the employer, whomever it might be, or whoever it might be, I guess is more correct. And you form a contract that lasts for the 3 years. Now, the contract is subject to being breached. Contracts are always subject to being breached for some reason or another. So we have what we refer to as grievance arbitration. If some person feels that they have been put upon, and the put upon as a violation of the collective bargaining agreement, then that person, through its union, through his or her union, can file some kind of practice, unfair labor practice, if it's that kind of a situation, or a grievance which is provided in the contract with some form of resolution, normally through arbitration. That's the form of a collective bargaining agreement, and that's the form of a resolution of the collective bargaining agreement. How do we get a collective bargaining agreement? A collective bargaining agreement, as I mentioned earlier, is a negotiation between a group of employees and the employer. But this is not always easy. It's not something that you just walk in and say, this is what we want, and they say, okay, this is what you get. It takes some kind of negotiations, and negotiations don't always result in a decision or an agreement between the parties. Very frequently, and this is how I make a living, very frequently it leads to a situation in which the two parties do not agree. There are certain provisions within the contract that they agree on and certain provisions within the contract that they do not agree on. So at that point, they get into contacting either a mediator, if they're at that level where they think they can resolve it by having someone perform a mediation between the two parties, or an arbitration. Of course, there's a big difference between mediation and arbitration, and again, it depends on the type of an organization, and it depends on the state law where you're operating. But let's take mediation, because that's the same everywhere. Mediation is a voluntary process where the union, a group of employees, or even in the case of an individual contract, an individual employee tries to change a contract or write a new contract or make some corrections to the contract, and they can't come to an agreement, so they go to mediation. They request and obtain a mediator. The mediator is a neutral, not with any axe to grind on either side, and the mediator comes in and, performing some kind of shuttle diplomacy, goes from one to the other, trying to work out the details of the agreement until they come to some kind of a meeting of the minds. That's the normal way it's done when it's a case in which there is no compulsory arbitration. If there's compulsory arbitration, as there is in some union agencies in Massachusetts, for example, and I'll give you the best example, where There is mediation may work. If it doesn't work, what's the solution? The solution would be, in some cases, and I'll give you an example in particular, where it becomes and goes to compulsory arbitration. In Massachusetts, the Joint Labor Management Committee provides for obligatory arbitration when parties cannot resolve if they're police or fire unions. Police and fire unions, they're not allowed to strike. Of course, no public employee in Massachusetts is allowed to strike, but many of them do. Teachers do in many cases. But police and fire, they can't afford to take that kind of a chance. So there is an agency called a Joint Labor Management Committee, and that agency may appoint an arbitrator. Usually it's a group of 3 arbitrators, one management, one neutral, and one for the employee. And that they hold a hearing, they listen to both sides of the story, and they come up with a solution, and the solution is obligatory. It's compulsory arbitration, and both sides have to accept the decision of the arbitration panel, with one little exception. This gets complicated sometimes, and I'm not trying to make it complicated. I'm trying to make it simple. But this one example I give you is that if the Joint Labor Management Committee panel of arbitrators decides on a certain course of action and says this is the way the new contract will be written, or this is the way this grievance will be resolved, then if it costs money, it has to go to the town meeting. If it's a municipal organization, police and fire always is, then it has to go to a town meeting to appropriate the money, and if they can't get an appropriation of the money, then they go back to the bargaining table. So the whole process just has to be repeated all over again. But that's the way it is in this business. It's not simple. How do you get an arbitrator? How do you get a mediator? How do you resolve a grievance? Well, there are agencies in all the states in the Union. There are national agencies. The national agencies called the American Arbitration Association is the most popular and most basic and most commonly used. In addition to the American Arbitration Association, there are all kinds of smaller organizations, usually within states. The state of Massachusetts, for example, has a board of, I speak for the state of Massachusetts primarily because that's where I practiced law for some 25 years before coming up here. So the state of Massachusetts I use as an example, although I am licensed in New Hampshire and Vermont. It's quite different in New Hampshire and Vermont because they're much smaller. But in Massachusetts, there's the Joint Labor Management Committee that I've already mentioned for police and fire. There's a Board of Conciliation Arbitration. There's the State Department Human Resources Division. I think that's all in Massachusetts. Then New Hampshire has a Public Employee Labor Relations. Maine does, Vermont does. They all have agencies. And if you have a grievance, or if you have a contract that's expiring and you want to renew the contract, then in either event, you get to a point where you can't come to an agreement. Then it goes, the parties, normally the contract between the parties will determine what agency the parties will use. But once that's determined, the parties would go to the agency, ask for an arbitrator or a mediator, depending on which is appropriate. And the agency will send a list of maybe 10 arbitrators, mediators, whatever the case may be, to the parties, and separately, the parties will then look at the resumes, look at the names. Most of these people are known. They have a record of some kind. And I don't mean a police record, I mean a record of decision-making. And they'll then, the sides will cross out those that they just don't want to on their panel or as their arbitrator or mediator, and then prioritize the others by number. It goes back to the agency. The agency then puts the numbers together and appoints someone as an arbitrator or mediator, whatever the case may be. And that's the person that handles it. Let me take 1 second here. Well, I wanted to mention there are 3 different kinds of arbitration activities. They're called something different. There's mediation, I've mentioned. Arbitration, I've mentioned. There's a third thing called fact-finding. Fact-finding is really an non-compulsory arbitration. So if you hear that term or you understand what that term means, fact-finding means not, and the only place I know where it actually works is with this Joint Labor Management Committee that I previously mentioned, because their arbitrations or decisions are obligatory until it gets to the appropriation of money. But in some cases, the parties don't ask for arbitration and they get what they call fact-finding, which in effect is a non-compulsory decision made by the panel. I mentioned a couple of times grievance arbitration. Grievance arbitration is different from interest arbitration. Interest arbitration is a renewal of a contract or the determination of the terms of a new contract, whether it be an initial contract or a secondary contract or a contract renewal. That's what we're talking about when we talk about interest arbitration. But then there's such a thing called grievance arbitration. Grievance arbitration has a different name, and it's because just what it sounds like. It's a grievance that is filed by one member or several members or the whole union or the employer against the union where there's been a violation of the contract, and once again, this goes to arbitration. Now, in all cases, grievance arbitration, when it goes to arbitration to one of these agencies that I mentioned, is compulsory. Once the decision is made by the agency, the parties have to live with it. Unlike the contract negotiation, where the parties can refuse to accept it, it's not obligatory. The grievance arbitration, when it is decided upon by the arbitrator, is compulsory. Now, someone mentioned in the previous talk that everything old is new again. I think Pat put that on the board. Just in closing here, let me just mention something in particular I happened to pick up here at Dartmouth College in one of the classics department courses. It says arbitration of disputes, and this is written in something like 100 BC. The Romans inherited from the diplomacy of the Hellenistic world the principles and procedures of international arbitration developed over centuries by the Greeks. Under Roman hegemony, Greek cities frequently referred disputes to the Senate for authoritative settlement, and the quasi-independent Allied states were required to do so. Sometimes the Senate assigned to a neutral entity with power to find a verdict in a field of inquiry precisely delimited by the Senate or the Roman provincial governor. We're talking about arbitration, which probably is somewhere in the order of about 3,000 or 4,000 years old. So I think it's important to understand that this isn't something new. Thank you. I'll be ready to answer your questions.
So now I just look at it. Yeah, you'll say something first, and Karen will know to change the lights. Okay.
Hi, I'm Bill Phillips, and I'm a writer and I teach here. I've written about 50 movie scripts under contract. Probably about 25 of them have been made in one form or another. Some large screen, some small screen, cable, network, or feature. I just want to give you a little bit of background about the Writers Guild. Back before there was a guild, and I mean before the 30s, producers used to have a habit of giving credits, screen credits for writing away to their lovers or their cousins or their golf buddies. And those of us who were writers, I wasn't born yet, but the founders of the Writers Guild felt that was wrong and wanted to take credit arbitration into their own hands. And they fought for it and they won it. In 1933, the screenwriters, what was it called then? The Screenwriters Guild was formed. In 1954, it became the Writers Guild of America. nobody likes to strike, and I've been a member of the Writers Guild since 1980, and participated in 2 strikes now. And I've also participated in attempts for years trying not to strike in between the strikes that we did have. We didn't get health benefits as writers until we struck. We didn't get pension benefits until we struck. I should also say, and Patty, you might have to correct me later, but my understanding as a layman, really, of the difference between unions and guilds is that a union you have to belong to. A guild, studios and networks can hire non-guild members, and people don't have to continue. People can continue being non-guild members. However, a studio or a network has to pay what the MBA, the minimum basic agreement, is negotiated as. They have to at least pay the minimum, even if you're not in the guild. It got a little fuzzy with the Writers Guild. There's a Writers Guild East and a Writers Guild West. They're really the same organization, demarcated by the Mississippi River, although the Writers Guild East has hats that say a creative union, and the Writers Guild West never talks about union. So, in my experience, the big bad strike was 1988, and it was over gross participation. There was no disagreement finally between the producers. Well, I should say something about the producers too. The AMPTP is the Alliance of Motion Picture and Television Producers. It's not the thousands of producers there are. It's 5 or 6 guys who have a lot of money and control everything. They hire the producers. So when the writers are on strike against the producers, I know many producers who have no power other than the power to go up. The power is really vested up higher, and you'll see it in a minute what I'm talking about. There was no disagreement that we should participate somewhat in gross revenues. The problem was, should we define it as producers gross or exhibitors gross? Exhibitors gross would mean, for example, if the Nugget Theater made $100,000 on a film, and you were entitled to say 1.5% of that, you would get 1.5% of 100,000. That would be exhibitors gross. Producers gross, let's say, and this varies greatly, so it's a little complicated. Sometimes the Nugget, for example, would send 90% of the revenue back to the studio. Sometimes they would send 10% of the revenue back to the studio, depending on the movie. If it's Star Wars, it's more likely to be 10%. But at any rate, producers gross is only 50%, let's say, of what exhibitors gross is. So if they made $100,000 and they sent $50,000 back to Paramount, writers would be entitled to 1.5% of that. Obviously, makes a huge difference which gross you choose. You get a 57-cent residual, or you get a $1.14 residual, or you get a $9,000 check, or you get an $18,000 check. There are 12,000 members of the guild, so it adds up to a whole lot of money that somebody is or is not getting. Back in 1988, we checked with the National Labor Relations Board, and apparently in other industries, the feeling was that we were going to prevail, and producers gross exhibitors gross was going to be given to us. Our executive director at the time unilaterally decided to sign with them, and we fired her. But I think she's probably living on an island somewhere in the South Pacific, because it cost us millions, tens, probably hundreds of millions of dollars over the years now. So we went on strike. And it was a nasty strike. Strikes hurt not only the network and the studios and the writers, but the valet car parkers, the restaurants had to close because in Los Angeles and probably in New York, most meetings take place over a meal. Agents meet, writers meet, studio readers, studio executives meet at lunch or at breakfast. There are agents who have 3 or 4 breakfasts a day. They have like a little piece of salad or a little piece of, cup of tea or something. At any rate, they said that they would get even with us for this. We shut the, I have it written down here what the dates were, I think. It was called the Bloodbath of 1988. And the 2 ways they did they said, we're going to get even with you for what you did to the industry. And the 2 things that they did was, one was to severely curtail what was called development. It used to be that there were many writers who would make a really nice living writing scripts that never got produced. It's not, a script, even a really well-paid writer, and let's say, just for the sake of easy math, very few writers get $1 million a script, but let's say for math, a writer gets $1 million for a script. The average major studio movie now costs $120 million. So we're talking about less than 1% goes to the writer. That's one of the reasons that screenwriters there are all sorts of jokes about the powerlessness of screenwriters as opposed to authors and playwrights. They figure we're well paid, but we're not that well paid. So what they did, the studios changed from developing about 100 scripts a year to developing about 20 scripts a year. Again, using easy math, let's say an average script would be $200,000. That created a pile of money at each studio of $16 million that they weren't spending on development of scripts. That meant that they could use the money to, if they saw a script they really liked, they could just outright buy it. But that also meant that the risk shifted from the studio to the writer. So writers suddenly, starting in 1988, started writing on spec, and it was not unheard of to hear of scripts selling for $3 million, $4 million. What was in it for the studios is they had the money there, and they would only buy it if they wanted to make it. So that was one of the changes. The other change you see all the time, and that's reality television. Now, I don't know who thought of the term reality television, because it's anything but that, but and most writers hate reality television. But that's what we inherited. We were told, once the strike was settled, that yes, we're sorry about the little confusion about about producers gross versus exhibitors gross, but it's the network, rather the cable industry is in its infancy, home video is in its infancy. We will negotiate in good faith and give you a bigger piece of the pie over the years. Just wait and see. And we waited and we waited, and it never happened. We never got a bigger piece of the pie. What happened last year was we decided that the future of media is in digital. Studios are going to start sending instead of big film cans, they're going to have satellite transmission of their product to theaters around the country. You in your living room are going to be able to, on your widescreen television with your surround sound, you're going to be able to have the movie experience without even having to go to Netflix. In fact, Netflix is starting to do it so that they don't get left out of the action. Soon there will not be video stores, probably. They will just be downloads. So that was our leap of faith. We said, yeah, this is the way it's going. We would like a piece of that. They didn't want to negotiate that at all. And I know friends who were producers who thought of ways, who even invented ways that they could accommodate the writers' needs to participate in this, and the AMPTP would not let them bring that up. So that's all I want to say now. I do want to show you two very brief videos. So Kara will, thank you.
Right now, Disney has $35 billion in annual revenue. How much is coming in from digital?
It's about $1.5 billion in digital.
Viacom will double its revenues this year from digital.
Tell me how you see all of this, the media, the digital revolution reshaping media, because you called it a new golden era.
Well, I hope it's a golden era. It is certainly one with golden opportunities.
Content is going to be more and more and more important. We all have PDAs, we all have cell phones with screens, we all have experienced the screen in the back of the taxi cab, the screen inside the elevator, and we are one of the best companies in the world at feeding those screens.
Perhaps CSI will be on the network, and it also will be on broadband. And at some point, instead of 27 million people watching it, 20 million will watch it, and 5 million will watch it on the internet. But we will get paid for it regardless. We as the network, as the studio, as the producers, as the production company, we're going to get paid no matter where you get it from.
Now, someone suggested that these are kind of biased representations, and I don't deny that. Here's the other biased representation.
Hello, and welcome to what is obviously not The Daily Show. I'm obviously not Jon Stewart. I'm Jason Ross, one of the show's 14 writers. Our top story, really our only story, the ongoing writers' strike, which began last Monday after talks broke down between writers, seen here working slavishly for your entertainment, and media company CEOs, captured here in their natural habitat. It's about whether writers should get paid when media companies make money using their work online. Writers think they should get paid. Corporations think the writers should go until they're herpes in their nasal passages. And I gotta say, they have a point. I mean, this is the internet. It's not about money. Online, you know, intrinsic worth is measured in things like number of tears shed over Britney Spears by a heartbreakingly gay teenager.
Leave Britney alone!
And while we're sad over this state of affairs, we're clearly not that sad. Besides, media conglomerates say it's too soon to put a dollar value on internet content. They say what's that? Viacom is suing YouTube for $1 billion for using its content online? $1 billion? That can't be right. In fact, I can't even believe it. Unless there's some sort of Daily Show style montage.
Viacom, the parent company of Comedy Central, has sued YouTube for over $1 billion.
$1 billion lawsuit.
$1 billion for copyright infringement.
A whopping $1 billion.
$1 billion Clash of the Titans.
More than $1 billion.
Saying, hey, you can't put our stuff out there for free.
You can't put our stuff out there for free. That's a catchy phrase. You mind if we use that and don't pay you? But is there anyone much older and more personally identified with Viacom who could help us make our case?
Say hypothetically, if someone filed such a lawsuit, what would they expect? Money? They would expect the protection of their rights for the future, and they might expect a deal that reflected the value of their content.
No. It may seem Redstone's YouTube stance contradicts his stance with the writers, but it's really quite simple. When you're not paying him, you owe him $1 billion. When he's not paying you, he's not paying you. sites. It's just so confusing. I mean, the value of internet content, it's really impossible when you think about it. I mean, oh, come on. 3 months ago, Viacom CEO Philippe Domon told investors his digital properties, like thedailyshow.com, are worth $500 million a year in ad and download sales. $500 million? Come on! To a pessimist, that's like half not $1 billion, right? Rob Kuttner wrote that joke. Anyway, we've taken a page from Viacom's playbook and sold some ads right here. Huh? They're paying us $100. And just to be fair, we're going to send Viacom $2.50. After all, we are using their idea. In other news, Pakistani President Pervez Musharraf...
Hello there! I'm the president of Viacom. My name is John J. Viacom Jr. III, and I've come here to tell you to cease and desist. We own these jokes, and they're worth $1 billion!
Is that right?
Indubitably!
Then can we have just a small percentage of that?
No!
Why not?
Because they're worthless!
Well, which is it? Are they worth $1 billion or worth nothing?
Wait.
That's...
God!
Getting paid is the name of the game.
Good afternoon. Thank you for inviting me here. I'm going to follow, I'm not sure I can follow that, but I'm going to come after that and talk a little bit about what we're seeing in the print and digital print arenas. Strikingly similar in lots of ways to the writers' strike and to the desire to be paid the appropriate rent for your efforts. So I'm going to look a little bit at what's going on, especially around Google Books, which is the big game in town at the moment. And then to move on to finish up, to look at labour and creativity slightly more broadly in the digital space, in blogs and wikis and so forth. If anybody's blogging or twittering this, you're more than welcome. So there's been an interesting sort of flurry of activity around when a book isn't a book. For the last 7 or 8 years, the first major salvo was this one. Freelance writers sued successfully the New York Times, arguing that the New York Times could not take their freelance content for which they'd been paid, that had appeared in print, and turn it round and put it online in an online version of the New York Times. They argued that they had rights in those electronic distributions that they were happy to be paid for, not richly paid for given the compensation pool, but you couldn't simply do it. You couldn't simply say, but it's still the New York Times, and we've already paid you once. So that was the first salvo in what's become a set of these sorts of disagreements, these sorts of conflicts. A much more interesting one about the same time, which probably passed you by unless you were deep into the ebook world, as I was then, was Rosetta Books, tiny little operation run by Arthur Klebanoff in New York, who looked at standard book publishing licenses, contracts with authors, and determined that until very recently, none of them said anything at all about electronic rights. The publishers all behaved as if they did, because that was the easier position. But Arthur concluded that these things were limited in their scope. They didn't cover movies, everybody knew that. They didn't cover serialization rights, everybody knew that. And he claimed they didn't cover ebooks either. He went round and quietly signed up a whole bunch of major authors, Kurt Vonnegut, various estates of other major authors, launched Rosetta Books and started selling these. They were PDF files, essentially, nothing flashy, and they were $6, $5, whatever they are, still exists. You could buy George Orwell, you could buy a number of major authors. Very beneficial if you were looking for a piece of ebook content. Certainly the publishers weren't selling it you. Not surprisingly, Random House took the lead on this. It wasn't a guild that sued, and essentially said, these are our authors. And tried to argue that the contracts that were signed sometimes 20, 30 years ago included this form of the book. So we had the really intriguing, apart from this sort of David and Goliath clash, we had this really intriguing need for a court to determine what's a book. We'd never needed a court to tell us that before. It's like having a court determine what are socks. I mean, it was fairly obvious. But as we moved into this, even these very early moments of the digital, online content world, we needed somebody to tell us. And it's a fascinating case. It's all there on the website, on the Rosetta Books website, if you want to read it. And the eventual decision and the appeal went the way of Rosetta Books. It was determined that indeed, when you signed that original contract, you weren't thinking of an electronic book. And the electronic book, even though it looks just like a page on a screen, these are not multimedia extravaganzas, was different enough that it required a new agreement. So the authors actually won there. There's not a whole lot of revenue coming in from ebooks at the moment, but the rights issue after this tussle was settled. And it was, for those of us on the sidelines, quite entertaining to see a major force like Random House being told they couldn't have their way just by asserting the way they wanted the world to work, especially over rights that they had at that time no ability to exercise. They weren't saying, we're selling these ebooks, you can't go ahead and do it. They had no ability to exploit this right. So it was a nice restatement in some of these conflicts that if you have a right, you also have a responsibility in this sort of setting to exploit it in the interests of your author in this case. Much more interesting, much more current is the array of clashes that are going on around the Authors Guild and others and Google. And as I'm sure you know, if you've been following this, and inescapably, if you haven't, Google moved in 4 years ago and is scanning essentially entire libraries or major chunks of them. Michigan, Stanford, Harvard, Oxford, New York Public, and the list has been growing over the last few years. They set up massive digitization operations, and they pump the books through. This is not a selection process, it's clear cutting. You want everything. Get duplicates, doesn't matter. Get the same book from 3 different libraries, it's more trouble to sort that out than it is just to suck the things in. So it's a huge hoovering operation. An awful lot to like about this from the perspective of a scholar and a reader, and a school child maybe. This is a lot of content that's largely dormant that's now available on your computer. 7 million books to date. The ambitions are considerably higher than that. This is a big money operation. And they have a related publisher program where if you're a publisher, you can send content in and they'll put it into Google Books as well. And when it comes up, if it's in both cases, if it's in copyright, you only see pieces. You've probably done this. And you get a pointer off to where you can buy it, or a library where you can find it in your zip code area, in the States at least. Or if it's an out-of-copyright book, you get the whole thing. And you can download it and you can do other things with it. So it's either free or it's a limited view at the moment. The publishers were not delighted about this. They were slightly confused about which bits they weren't delighted about, but they generally agreed they didn't like it. And they didn't like it because they had not been asked permission. Google's original point was, this is like going into a bookstore. Right? You don't have to pay the publisher anything if I go into Barnes & Noble, sit in their comfy chair, which they provide me, and spend a while reading a book. I only pay if I leave the store with the whole thing. So their argument was that Google's argument was that these glimpses without any agreement with the publisher was fair, was reasonable, and indeed was driving traffic to the publisher's sites, which is certainly demonstrable. But there's been an extended clash over this, and I think as Google's ambitions to sell some of that content, not just to give glimpses away or give the whole thing away, but actually to be an iTunes-like operation to sell it, then you need a structure in place. So the combination of those two things led first to a lawsuit and now to a settlement that's almost done. It still needs to be ratified, where essentially Google will pay to set up a mechanism by which the sales and the rights can be tracked, and will pay into that process a 37-63 split so that the owners of the content will get some of the revenue that Google generates by selling either individual books to you or great clusters of books to libraries in various sorts of aggregations. So this one is actually moving forwards in a way that seems relatively equitable. There'll certainly be a lot more content there. We're already beginning, though, as this moves on, to see unintended consequences. Well, things we hadn't noticed necessarily. They may not have been unintended to all parties. But as Google sucks all these books into its central pile for all the terrific things that allows us to do, when you go on to Google and even other places and look for these books, you find the copy in Google Book Search first. You don't find the copy in the publisher's side, even if they've got it up as well. Or we're beginning to realize in the library, where we may also have it up, maybe licensed from Google. So what it's really we're beginning to realize that there's a cloud on the horizon here potentially if you want to be the avenue through which your community gets this content. If Google is the most prominent place you're going to find that, you're always going to come through Google. A bad thing? It has some downsides if you're looking to create a community around that content. Just last week, the Authors Guild, who are very active at the moment, the authors seem to be kind of spooked, decided they didn't like the new Kindle. I don't know if I should have put a picture up here, but you've probably seen a Kindle. It's one of these book reading machines. Amazon has sold 400,000 of them. And it's a one-use device. It doesn't do anything else, but it's wireless, and you can buy book content into it. And the second version came out last week before last. And now it has audio, not for playing music, but it has a text-to-speech synthesizer built in. So this isn't new. Microsoft Reader has had this, which is software-based, which has had this for 7 years. But suddenly now, when you buy a piece of content through Amazon, and the writer gets his cut or her cut, you've also got a low-rent audio book. You know, this isn't John Gielgud, this is a robot voice, but Gielgud's dead and there's only so much that real people can read. I mean, I don't know if this will actually work, but I might be able to give you a hint of what this sounds like just off my laptop here. This is not the Kindle.
Marley's ghost. Marley was dead, to begin with. There is no doubt whatever about that. The register of his burial was signed by the clergyman, the clerk, the undertaker, and the chief mourner. Scrooge signed it, and Scrooge's name was good upon change for anything he chose to put his hand to. Old Marley was as dead as a doornail.
The thrill wears off, but the thing won't stop. So that's what they're exercised about now. This is suddenly a new right. Excuse me. Well, robot voices don't like to be hushed. So it's kind of goofy, it seems to me. I mean, this isn't really, it's hard to imagine that's a right you can sell. But it does raise the interesting prospect, especially late at night, putting slides together like this, of all sorts of other rights issues. There's a lot of rights potentially built into the recontextualization of this content. So if avatars in Second Life act your play, is that a performance right that they should have licensed? These are not real, they're avatars, right? If robots act them out, if you build a virtual world of a book and its landscape, conceivably the names of pieces are covered, but what if you name them something else? Is that covered? We've been talking for years about home-based print on demand and bind me a little book machines. And there's a little bundle of horrors around that, I'm sure. So I suspect what we're going to see, and none of this is new, of course, is an increasing number of these, wait a minute, that's mine, even though the offended party, in this case, has done nothing to make those entities happen. They're just reacting again, from the outside, they're just reacting against something that's vaguely useful to some party. We have other things going on in scholarly communication, of course, where we've moved swiftly to online content, online journals. We pay dearly for them. But we haven't quite broken this cycle. We haven't begun to break the cycle, in fact, where we're writers who create intellectual content, not fiction, but other types of scholarship that's highly valuable. We also peer review it to make sure the good stuff comes up to the top, and then we give it away to publishers, and then we buy it back. Stated that way, as it often is, it's kind of hard to see how do we get into this mess. You wouldn't design a communication flow where you do all the work and then you give it to a third party and spend collectively a lot of money. I'm trying to see the right figure here. But certainly millions of dollars per academic library across the States and in other parts of the world to buy back content you just built collectively. Certainly around that, and there are other people in the room who can talk to this, there's a whole bundle of things as you begin to unpack this that go to reputation. And the point I'm going to finish on, to leave time for questions, is that in addition to all this interesting stuff that's happening by companies like Google bringing content back, if not from the dead, then certainly from the obscurity of library shelves where it hasn't circulated for many, many years in some cases. Good for us, however, for keeping it and keeping it viable that long. There's also this other thing that's happening as we start to move into digital networks for communicating. And it's happening in the scholarly world, it's happening rapidly outside it. And it's something actually we're quite familiar with in the academic world. We often do things that have value for which we're not immediately directly compensated. We give a talk, we go to a conference, we do peer reviewing for journals, rarely compensated. And we do it because it builds our reputation. It cements us in a community. It pays off when we come up for tenure. It pays off because we get invited to do something, to write a textbook that actually does make money. So we've long done these, and we're not unique in this. What we're seeing, I suspect, as we move into digital workplaces, if we can treat that as a fairly broad phrase, as we move into blogs and web pages and so forth, is this working for stuff, for labor for stuff other than money, is becoming much more mainstream. A couple of quick examples, just to try and put some examples around what I'm saying in case it's not clear. Lots of people in their business arena, in their area of hobby interest, labor, quite literally, online to populate sites, to bring their expertise to evaluate content. Slashdot is a site for programmers, open source programmers and geeks. Splendid site, been around a very long time, and it worked out very early on that if you had all these people with expertise coming, you could harness that expertise to push certain things up and suppress certain things. So when you comment or post, the rest of the community can say excellent or terrible. Turns out funny isn't very helpful to your karma, and that builds up your individual karma, as the word they chose, but it builds up your sense of your place in that community. You earn the right to be heard higher up the list, or to push something higher up the list. If you ever bought from eBay, you'll know how important vendor approval is. You want, as a vendor, to have very happy customers, because if not, your score goes down, you get bad comments attached to your name, and other people won't buy from you. Wikipedia is the best example, where you have an entire operation created by people not being paid that's created a source that many of us use. And this is this notion of labor and creativity is beginning to bleed into the mainstream business press. There was an article just recently on websites like This Next, where people with, in this case, fashion and shopping expertise spend a lot of time sifting through things to be able to go to this site and say, here, this is the hot new whatever it is of the moment. And the creator of the company really thinks of this as building a personal brand, of laboring through your expertise and your creativity to build yourself into something that's marketable online, to win praise, to earn an exalted place within this online community, the thrill of winning and of helping others. There's potentially an altruistic angle to this. So a whole new type of labor and creativity. And then to finish, slightly off topic, but the last speaker can sometimes veer off without derailing anybody who comes after. As I was thinking through, as I was looking at the Google Books and the ebooks piece of all of this, and the clashes and the resolutions that we're seeing there that are really resonate quite closely with the writers of film that we saw earlier. And then as I thought about these other ways that people labour in this new environment, which we're going to see, of course, major shifts in as the environment settles into more and more parts of our lives, I realised that when I look at the workplace literature, there's a lot of talk about the generation that's hitting the workplace now, the millennials as they've been called, our students here at Dartmouth, who have different ways of engaging because they've sort of grown up on the network. I forget who coined this phrase, but I'm happy to borrow it. There's a sense of a constant state of partial attention. You can't do one thing. You can talk, but you're only if you're checking your email. It's not that you're being inattentive, but somehow doing one thing is uncomfortable. We talk a lot about how they're networked, how they've grown up on the network. I'm not sure that's quite so true. How they have delayed adulthood because their parents won't leave, and they don't want them to. That they're team-oriented, that they expect more of a balance. All of these things may be true, but it's certainly beginning to impact the work and the workplace. It's too early to know how much they change when they hit the rest of us and are corrupted. But I am quite sure, as I run my own experiment at home on Eleanor, on Julia, and on Ben, my 3 children, that the ones who are 5 years out from us, and they've been called digital natives recently, when we start looking at these topics that we're talking about now, and they're in our midst, they're in our colleges, they're in our workplaces, their world and their assumptions are wildly difficult, maybe difficult for us, different. They don't remember a time without the iPod. They certainly don't remember a time without the internet. They're deeply engaged in social networks. Neopets, for those of you who've got 10-year-olds probably will know, stickiest kids website there is, huge. They think nothing about using object-oriented programming. If you've never seen MIT Scratch, my 9-year-old can build a perfectly nice little animation in Scratch, send it to his uncle in the UK as a thank you note. So they think nothing about coding online. And they edit video as easily as I do words. So when these folks hit, we're going to see in all of these areas, including in creativity, a huge shift, I suspect, that we really haven't seen yet. And to cycle back to our title, this group coming at us now in grade school and early high school, they won't have labour and creativity in the digital age. They'll just have labour and creativity. There is no digital age for them. It's the only one they've ever had. So on that, I think that's a cheery note. On that cheery note, I will finish and turn this over to questions.
Well, thank you so much to our presenters. We covered Greece to Google and digital natives. Expansive, to say the least. We'd like to get a couple questions in. I asked that you use a microphone so our recording can take you in. Pat Palmiato has a microphone coming down, and we've got a taker.
Yes, is this on? I was unclear as to the result of the writers' strike. Can you explain what happened
we
ultimately?
Won. It was a Pyrrhic victory, but we won. We won a percentage of the digital revenues. The bad part is that digital revenues are hardly exist. This thing that we're hoping for hasn't quite happened yet. I actually think the reason we won has less to do with the Writers Guild than the fact that we were backed by the Screen Actors Guild and the Oscars were coming up and the AMPTP, which is the Oscars, could not see. The actors would not cross the picket line. They had already shut down the Golden Globes, and I think the AMPTP didn't want the actors to be supportive of the Writers Guild. So, but I mean, that's a very broad answer, but we think we won. It's been called the most effective labor organizational activity in the last 25 years, and I think it's because the Writers Guild was united. There was like 95% compliance, and also because we won the PR war with the public was on our side.
I'm wondering if let us know this.
Can't hear you.
I'm wondering if I can see this from both sides. Like, in other words, like maybe let's say Slumdog Millionaire, the movie. Like, on one hand, there's a risk that the managers and whatever have to do that provides a platform for the movie to exist. But when it's really wildly successful, you start to wonder about, let's say, the child actors. I mean, are they being supported? And so I guess my question is, are we moving to a point where pretty much as employees, there's nothing less that'll be acceptable except ownership? That, in other words, if you participate in something, it can't just be that you participate and walk away, but you are forever an owner in whatever you create.
I guess you're looking at me. I don't know quite why. I think your question is more a question of intellectual property than it is employer-employee relations. Intellectual property, just like copyright law, has a certain time. I think the latest I remember somebody mentioning was 60 years after the death of the person that wrote the book or something of that sort. So if that's what you're talking about, a person who creates something, how long does that person have any claim on what that person has created? And the answer to that is, who holds the copyright? Who holds the trademark? And if it's an author who writes a book and the book is published by the publisher, there's a contract between the publisher and the book writer as to what happens to that copyright. I know my wife's written 3 books, and she's given the copyright to the people about whom the books were written. So it depends. That's a good answer every lawyer will give you. It depends.
I mean, in a sense, though, you're asking the question of, is, a performance something very different than a widget? So if I use my labor to make a movie, should that be treated very differently from if I use my labor to make shoes? When I sell my shoes and you go and wear them, I don't come track you down and say, I can't believe you just walked through that slush puddle in my beautiful shoes, right? I've sold them to you. And so I think there's been fluctuation in how we look at these sort of creative outputs of labor. We've historically always given copyrights for books. How do we treat something like performance in a movie? Is it yours forever? You typically have gotten residuals, I think, in the past. But, at what point do you sell it completely away? And that's probably something that keeps being negotiated. You're more in the industry.
The first thing that a screenwriter signs away, even before starting to work, is copyright, so that Warner Brothers or Paramount or Fox or Universal owns the copyright to what I write, or to what any screenwriter writes. Interestingly, there was a Sonny Bono Copyright Act, which allows individuals get, it's their life plus 70 years, as I recall. But if you're a corporation, it's now I'm not sure what defines a corporation's life, but you get an extension of another 25 years. Corporations have more rights than people, and the reason for that is that Michael Eisner, when he was at Disney, was about to lose the Mickey Mouse copyright, and so he generously paid Sonny Bono and probably lots of other congressmen to support their campaigns, and in return they voted to allow Disney and every other corporation to retain Mickey Mouse and for another 25 years. So that's at work.
Yeah, there's we are beginning to see, albeit slowly, things like Creative Commons and other arrangements that aren't the public domain, that aren't old school copyright, coming along as a way, in part, to address the fact that the world, the opportunities that you have to reach audiences, to exploit content, if that's the right way of putting it, creative content, are different now. And for all the things it does well, the copyright laws that we have are still largely ones that were written pre the photocopier, pre the computer. There's a wonderful law professor at Duke, Jamie Boyle, who runs the Centre for the Public Domain, I think, who challenges his students to violate the copyright of a book printed in the early part of the 20th century. And it's really hard, right? Unless you copy it out longhand or type it out and give it to somebody, there's no photocopier. You'd have to own a printing press to do it, and you'd need all the industrial mechanisms. And the laws that we've got are still largely ones that are designed for company against company. So there's a lot of alternatives and scrambling around to work out how can we have more nimble, fairer ways of dealing with a situation where content that maybe has run its life in its first medium comes back. I mean, Google Books is not the only example, but comes back to life, if you like, that has a utility, finds readers, finds performers, finds an audience through the agency of some party you had nothing to do with as the writer, and your publisher probably had nothing to do with either.
I think that the new technology is what really is testing us mostly in this ownership. Look what happened to the music industry. Illegal downloading is really hard to stop. Doesn't mean it's right, doesn't mean it will ever be legal, but it has had very definite ramifications in the way that music companies function.
Affecting films as well.
Yeah. No, I as a member of the guild, and I know this is also true for members of the Academy, we get screeners of movies so that we can vote yes or no for Best Picture. And each of the screeners is watermarked, individually watermarked, and we are told that we have to destroy these because if it ever shows up, let's say on the black market in China and is sold for $5, it'll come back to haunt one of us if it's got our watermark on it. So I mean, it's a real issue.
I just wanted to bring up the fact that I read in the Sunday New York Times, and I can't remember which section, it might well have been the book review section, an excellent history of the labor movement in the United States and the great sociological impact it had on our society and on our government. So if anybody wants to look back, they could find that as an excellent source. Also, I was amused by the presentations, having spent most of my adult life in Greece, and my husband's too, how tidy everything was. And we were just in Greece, just came back when the anarchists rose in December. It was fascinating, and I must say, very untidy. So we should be lucky that we live in this tidiness, no matter how complex the issues are that you brought up. There'll be no blood on the streets because of it.
I had a couple of questions. It seems in the writer's strike in particular, the big problem is that you're up against a cartel. If it really is this AMPTP, then, they have a lot more bargaining power than you do if they're all in cahoots. And so the fact that they're cooperating and colluding with each other means that you're sort of powerless if you don't. It seems like the natural consequence of that is there should be more writer ownership of downstream parts of the production process, arrangements with theaters and other exhibitors to show your work. To compete directly with them on the places where they seem to hold the cards would be one way to sort of resolve this.
There are discussions about that, and there are individual, as was, I guess, Pat pointed out, the guild will negotiate a minimum basic agreement, but individuals can say, well, you can only have my script if you will give me 4% of the gross, not of the net.
Right.
That, if you can have that ownership. Not everybody has that.
And the other part of this seems to be that the big fights come up with not a contract going forward, where now that you know some of the likely ways things will be distributed, you could put those in the contract or not. You could try to You know, this is why if you're not up against a cartel, you don't really need anything formal to get paid what you're worth. The person who protects you is the competing producer who wants your play a little bit, or wants your work product a little bit more. This was a knockdown, drag-out fight over existing content in a new medium.
Mm-hmm.
It seems like it would be nice if new protocols could be established within the industry for when the next cool thing happens.
Well, the free market, I think, is what's at play here. David Picker, who's a Dartmouth graduate and has been a film executive in lots of different studios, when he was at United Artists, he holds himself responsible for the high salaries that actors get now. Because when he was at United Artists, he said, I don't care who you are, you're not worth more than $1 million. I will not pay more than $1 million. And so United Artists started losing all the actors who could get $5 million by going to Fox, or $10 million by going to Paramount or Universal. And so that experiment in salary cap was a dismal failure, and that's why we now have $25 million salaries for some actors, for movies that cost a total of $27 million.
Yeah, I have a very quick question. I was curious about Rosetta Books. How do they make their PDF? As they photocopy it?
I don't know whether they had it typed in or whether they replicated the printed text. What I didn't say with Rosetta, who are still around and I think thriving, is the upshot of that was that they became the exclusive ebook distributor for Random House. So Random House simply brought them into the fold, and they had no such entity. In fact, they had not only did they have no such entity, but the rumor was that if Rosetta had lost that case, if the judge had decided that this thing on the screen was sufficiently like a book that the contract covered it, there was a mandatory licensing fallback where they could have said, okay, it's your book, but you're not doing anything with it, and you have a right to do it, and you need to license us to do it.
And I had one other question. I was curious on the grievance procedures, how they're managing now to reduce the workers' rights in things like General Motors, et cetera. If a person has retired and had health benefits and then they come along and take those away, do they rewrite the contracts? Do they just violate the contracts? How does that happen?
Good question. I wonder how it happens. There's certain things that we refer to as management rights. And management rights means that the management can do certain things. One of them in particular is reassign personnel from one job to another, reduce the hours of work, change the dates and days of work, reduce the number of employees, lay off employees. There's nothing a union or a collective bargaining agreement or a contract can be accused of being violated through one of those management right activities. Some of the things that you ask are a little bit more complicated. The issue of pensions, for example. Of course, pensions are pensions, but if a company goes bankrupt, that's the end of the pension. Most of the pensions nowadays in the last 20 years have been 401ks and not pensions anyway. Health insurance is the big thing. Health insurance is, I hate to say this because I'll be blown off the stage, but it's a gift for retirees. The contract does not include rights of post-retirement health benefits. It may be given, but it also may be taken away. I don't see that being a violation of any contract because the employee who's retired is no longer an employee, no longer a member of the union. I don't know if that answers your question, but it's not an easy issue.
We're pushing past 6 o'clock, so I want to take this time to thank the panelists very much for your time and your insights. If you'd like to offer us any parting shots, feel free to take this time to do so. No takers? Well, thank you so much for coming, and thank you.